Hey, welcome back to the Jon Gil Podcast Show. And on this episode, we're going to discuss the City of Chicago Residential Landlord and Tenant Ordinance. So stay tuned. All right, we're back. And on this episode, we're going to discuss the City of Chicago Residential Landlord and Tenant Ordinance Summary. So I have it here in front of me, and you can actually look this up. I think a lot of tenants sometimes have a misconception and feel that they have more. Well, let's put it this way. I feel like they expect that the landlord has to take care of 100% everything in their apartment, and that's not necessarily true. So that's why I wanted to pull this out today. And it says Chicago rents rights, good tenants, good landlords, great neighborhoods. So, on the landlord-tenant ordinance, it clearly states here, what are the tenant's general duties under the ordinance? So please keep this in mind. The tenant and the tenant's family and invited guests must comply with all obligations imposed specifically upon tenants by provision of the municipal code applicable to dwelling units, including Section 7-28, 859. Buying and installing working batteries in smoke and carbon monoxide detectors within tenant's apartment. So I've had tenants call me that there's a beep coming from their smoke and carbon detector and they want me to fix it. And I tell them, your battery is drained. Go change the batteries out of your smoke and carbon detector. And you would be surprised at how upset some of the tenants get. Listen, grab batteries across the street or wherever you got to go to. Change the freaking batteries. It's not a big deal. So, and it clearly states here, so now you're aware that that is your responsibility. Okay? Also, keeping the unit safe and clean. Listen to that again. You have to keep the unit safe and clean. What does that mean? That means if we happen to go there to, do a repair, and we walk into like somebody hoarding or, just a big mess, that's immediately in violation of the ordinance. So as a tenant, you have to keep and maintain your unit clean. All right. And it's funny because some of the same people that leave a mess in their unit are the ones that complain about rodents. And even worse yet, they're the ones that complain that there's a mouse trap, or that there's sticky glue and then they toss them out because it gets in the way. But it's like, how the heck are you going to prevent rodents from entering your unit? Obviously you're going to want to mitigate as the landlord around your building so that they don't get in the first place. But through the sewers, sometimes rodents can get in. So all of these things have to and that's why as a landlord, you want to keep, it's good to have an exterminator go out every 6 months, maybe once a year, 2 times a year, and then just ensure that the property is clean to prevent any sort of issues. Another one is using all equipment and facilities in a reasonable manner, not deliberately or negligently damaging the unit, and not disturbing other residents. That can include, and as a landlord, you want to also ensure that you have probably a non-smoking apartment because, there's nothing more annoying than having a neighbor next door that smokes cigarettes and stinks up their apartment, the hallways, when they walk into the building, anyway, whatever they do outside of the building, it's not a problem. But, that is a huge issue. So, to prevent some of these, also as a landlord, ensure that the tenant knows it's non-smoking. But as a tenant, please be courteous to your neighbor, with the music, with the banging on the floors, So keep that in mind. All right. Now, landlord's right of access, Municipal Code CH 5-12-050. A tenant shall permit reasonable access to a landlord upon receiving 2-day notice by mail, telephone, written notice, or other means designated in good faith to provide notice. So if there's a repair or for any reason the landlord has to gain access. He has to provide a 2-day notice, and he can get inside your unit. And this has happened a lot, where you'll place the notice, you've called, you've emailed, you've texted, you've done everything that you can in your power, and you still have a tenant that gets upset that you went into their unit. So as long as you have 2-day notice, the landlord has every right to get into your unit, okay? And in the event of emergency, now listen to this, in the event of emergency or where repairs elsewhere unexpectedly require access, the landlord must provide notice within 2 days after entry. So as a landlord, sometimes if there's an emergency, okay, so what's an emergency? An emergency can be a crazy leak coming from the kitchen sink that's damaging the neighbor right below. We can gain access right away because that's an emergency, and we'd have to provide that notice that we gained access to the unit within 2 days. All right? So keep that in mind as a tenant. Your landlord can gain access immediately if it's an emergency. And as a landlord, keep that in mind because sometimes, a tenant does not understand and feels that you violated their rights. So you can just basically take them to Landlord's Right of Access, Municipal Code CH 5-12-050. In fact, that's something great to have memorized because the second you bring that up and you give them that specific code, they just got to shut up. That's the bottom line. And I hate to use that word, but they have to understand, let's say, what the issue is. And I say that a little bit, upset because it just happens to me all the time where we have to get repairs done and it's just like pulling teeth. So, and you know what? And we're actually helping the unit. We're helping your neighbors. So you would think that there'd be like a friendlier and more kind of, you'd think that there would be a little bit more understanding when it came to that, but unfortunately there's not. Then there's something on security deposits I'm not going to go into because I don't recommend any landlord to take a security deposit at all. So I am just going to completely not even go there. And, continuing here is what the landlord general duties are under the ordinance. And that is that we have to give written notice of the owner or manager's name, address, and telephone number. That should be on the lease, by the way. And within 7 days of being served a foreclosure complaint, an owner or landlord of a premise that is the subject of the foreclosure complaint shall disclose in writing to all tenants of the premises that a foreclosure action has been filed. The owner or landlord shall also notify a foreclosure suit in writing before a tenant signs a lease. Municipal Code CH-512-095, EFF.11-05-08. And to give new or renewing tenants notice of providing code citations issued by the city in the previous 12 months. So if a landlord has had any city building violations within the last 12 months, you have to let those tenants be aware. Pending housing court or administrative hearing actions, they also have to be made aware of. Pending housing court or hearing actions, water, electrical, or gas service shutoffs to the building during the entire occupancy. To maintain the property in compliance with all applicable provisions of the code, of the municipal code. To not require a tenant to renew an agreement more than 90 days before the existing agreement terminates. Okay? So listen to that one again. To not require a tenant to renew an agreement. So that tenant, you can't force that tenant to sign a new agreement if it's more than 90 days. So if the tenant's lease is going to expire, you want to at least try to reach out to them 3 months, in advance or after, and then sign the new lease or the lease extension. Okay. And if the rental agreement will not be renewed or if the rental rate will be increased, to provide a tenant with at least 30 days if the tenant has occupied the apartment for up to 6 months, 60 days if the tenant has occupied the apartment for more than 6 months, and up to 3 years, and 120 days notice if the tenant has occupied the apartment for more than 3 years. So keep that in mind. 30 days notice if the rental agreement will not be renewed or if the rental rate will be increased. Okay? If they've only occupied for 6 months. And a 60-day notice if they've occupied it for more than 6 months and up to 3 years, and 120 days if the tenant has occupied the apartment for more than 3 years. Municipal Code CH 5-12-140. To not enforce, okay, and here's the other one, to not enforce prohibited lease provisions and bed bugs education for any rental agreement for a dwelling unit entered into or renewed after the effective date of this 2013 Amendment Ordinance. Prior to entering into or renewing such agreement, the landlord or any person authorized to enter into such agreement on his behalf shall provide to such tenant the informational brochure on bedbug preventions. Okay, that was long. Just give them the bedbug brochure. Okay, so as a tenant, you should have received a bedbug brochure, and that comes usually standard in the packet. So if you're not getting that, that's odd. Now, tenant remedies. Municipal Code CH 5-12-110 for minor defects. If the landlord fails to maintain the property in compliance with the code and the tenant or the tenant's family or guests are not responsible for the failure, the tenant may request in writing that the landlord make repairs within 14 days. And if the landlord fails to do so, the tenant may withhold an amount of rent that reasonably reflects the reduced value of the unit. Rent withholding begins from the 15th day until repairs are made. So if you're a tenant listening to this, you cannot withhold the rent if you're upset. You have to provide notice to your landlord, okay, written notice, and the landlord has 14 days to repair the issue. All right? On the 15th day, if it has not been repaired, then you can hold on to the rent for an amount equal to the reasonably reflects the reduced value of the unit. Now, request in writing that the landlord make repairs within 14 days, and if the landlord fails to do so, the rent may have the repairs made and deduct up to $500 or half of the month's rent, whichever is more, but not to exceed 1 month's rent. Repairs must be done in compliance with the code. Receipt for the repairs must be given to the landlord, and no more than the cost of the repairs can be deducted from the rent. And also, number 3, file suit against the landlord for damages and injunctive relief. So those are some of the remedies. Now, a major defect. If the landlord fails to maintain a property, or if the landlord fails to maintain the property in compliance with the code, and the failure renders the premises unreasonably fit and habitable, the tenant may request in writing that the landlord make repairs within 14 days. If after 14 days repairs are not made, the tenant may immediately terminate the lease. Tenant must deliver possession and move out in 30 days, or tenant's notice is considered withdrawn. So again, this is for a major defect. So there's minor defects and major defects. So keep that in mind. No matter what, you have to provide notice and keep that 14-day period, understood. And failure to provide essential services such as heat, running or hot water, electricity, gas, or plumbing, Municipal Code CH 5-12-110. If contrary to the lease, an essential service is not provided, or if the landlord fails to maintain the building in material compliance with the code to such an extent that such failure constitutes an immediate danger to the health and safety of the tenant, and the tenant or the tenant's family or guests are not responsible for such failure after giving written notice, the tenant may do one of the following. Number 1, procure substitute service and upon presenting paid receipts to the landlord, deduct the cost from the rent. Or 2, file suit against the landlord and recover damages based on the reduced value of the dwelling unit. Or 3, procure substitute housing and be excused from paying rent for that period. The tenant may also recover from the landlord the cost of substitute housing up to an amount equal to the monthly rent for each month or portion thereof. But again, keep that in mind. This is only for failure to provide essential services. So if your landlord is not providing you heat, Okay, now, if you are responsible for your gas bill and you do not pay your gas bill and they shut off the gas, that's something that you just want to understand, that your lease clearly states what you're responsible for as a tenant and what the landlord is responsible for. Procure substitute housing and be excused from paying rent for that period. The tenant may also recover from the landlord the cost of substitute. Okay, we explained that one. Number 4, request that the landlord correct the failure within 24 hours, and if the landlord fails to do so, withhold the monthly rent in an amount that reasonably reflects the reduced value of its premises. Rent withholding cannot start until after the 24-hour expires and applies only to days past the 24-hour waiting period. Number 5, request that the landlord correct the failures within 72 hours, and if the landlord fails to do so, terminate the rental agreement. If the rental agreement is terminated, the tenant must deliver possession and move out within 30 days of, or the notice of termination is considered withdrawn. So if you don't move out within those 30 days, that termination is considered withdrawn. So these are just specifically for failures to provide essential services. Not to be confused with tenant remedies, which we discussed earlier, about minor defects and major defects. And now any fire or casualty damage, if a fire damages the unit to an extent that is in material non-compliance with the code and the tenant's family or guests are not responsible for the fire or accident. Now listen to that. And tenant's family or guests are not responsible for the fire or accident, the tenant may, number 1, move out immediately, but if this is done, the tenant must provide written notice to the landlord of the intent to terminate within 14 days after moving out. Number 2, the tenant may stay in the unit if it's legal, but the tenant stays and cannot use a portion of the unit because of the damage. The rent may be reduced to reflect the reduced value of the rent. And 3, if the tenant stays and the landlord fails to diligently carry out the work, the tenant may notify the landlord in writing within 14 days after the tenant becomes aware that the work is not being diligently carried out of the tenant's intention to terminate the rental agreement and move out. Now, subleases. This is one that I get asked about a lot. Oh, I just got a new job offer in another state. I'm going to have to terminate my lease. No, you're not going to terminate your lease. That's not how it works. What you can do is you can sublease, and that person is going to have to, take over your lease essentially. And if they don't pay, you're still on the hook. Keep that in mind. Now, subleases, Municipal Code CH 5-12-120. The landlord must accept the reasonable subtenant offered by the tenant without charging additional fees. If a tenant moves prior to the end of the rental agreement, the landlord must make a good faith effort to find a new tenant at a fair rent. So if you move and you don't care and you're not going to go out and find a new tenant, well, the landlord has every right to go out and try to find a tenant to go into the unit, but you're still on the hook, all right? And we just have to do our best to find a tenant that has fair rent. And if the landlord is unsuccessful in re-renting the unit, the tenant remains liable for the rent under the rental agreement, as well as the landlord's cost of advertising. So, that's a great one. I can't believe I missed that one before. The tenant is responsible also for the cost of advertising. So, it costs to advertise $500, $1,000. Keep that in mind. As a tenant, these are things that you're going to be responsible for. And as a landlord, I would assume that the landlord has to provide a copy of the receipt to the tenant, even though it's not clearly written here, but that's something that should be done. What happens if a tenant pays rent due after the expiration of the time period set forth in a termination notice? Well, if the landlord accepts the rent due, knowing that there is a default in payment, the tenant may stay. So if you give the landlord even $100, you can still stay. So as a landlord, be very careful to accept payments if you want if you want that tenant out. You give them all the notices, not extending their lease, because the tenant does have the right then to stay. Now, here's our remedies as a landlord. Landlord remedies, Municipal Code CH 5-12-130. If the tenant fails to pay rent, the landlord, after giving 5 days written notice to the tenant, may terminate the rental agreement. However, the tenant may remain in the unit with the rental agreement in good standing if the tenant pays the full amount of back rent and landlord court filing fees before a judge issues an order of possession. If, however, the tenant uses this provision and later receives a second written notice of non-payment, the tenant will have only 5 days to pay unpaid rent. If the tenant fails to comply with the code or the rental agreement, the landlord, after giving 10 days written notice to the tenant, may terminate the rental agreement if tenant fails to correct the violation. So again, if the tenant fails to comply with the code or the rental agreement, the landlord, after giving 10 days written notice to the tenant, may terminate the agreement if tenant fails to correct the violation. And lastly, if the tenant fails to comply with the code or the rental agreement, the landlord may request in writing that the tenant comply as promptly as conditions permit in the case of emergency or within 14 days. If the breach is not corrected in the time period specified, the landlord may enter the dwelling unit and have the necessary work done. In this case, the tenant shall be responsible for all costs of repairs. And lockouts. This section applies to every residential unit in Chicago. There's no exceptions. And it's actually illegal for a landlord to lock out a tenant or change locks or remove doors of a rental unit or cut off heat, utility, or water service, or to do anything which interferes with the tenant's use of the apartment. All lockouts are illegal, and the police department is responsible for enforcement against such illegal activity. And the landlord shall be fined $200 to $500 for each day the lockout occurs or continues. You know, sometimes, just as a landlord, just don't do it. You do not do it. The tenant may sue the landlord to recover possession of the unit and twice the actual damages sustained or 2 months' rent, whichever is greater. And prohibition of retaliatory conduct by landlords, Municipal Code CH 512-150. A tenant has the right to complain or testify in good faith about their tenancy to governmental agencies or officials, police, media, community groups, tenant unions, or the landlord. A landlord is prohibited from retaliating by terminating or threatening to terminate a tenancy, increasing rent, decreasing services, bringing or threatening to bring in an eviction action, or refusing to renew a lease. And I actually had a tenants union come after us because we purchased a building, and we bought the building from a senior citizen. I think he was on his deathbed, and his family actually had the authority to sign on his behalf. Well, what happened was these tenants took full advantage of this poor guy, who was on his deathbed, hadn't paid any rent for probably 8 months, and then when we took over the property, we provided the 30-day notice of termination. And it was either a 30 or 90-day notice of termination. I can't recall. Well, long story short, they got upset, or actually one of the guys got upset, went to a tenants union here in a neighborhood I'm not going to mention, and came to my office and demanded to speak to me while I was in the middle of a meeting, and I couldn't set that meeting up. Obviously, I said, you're going to have to please schedule at a different date. So he gives me like this crazy smirk. He walks outside, and next thing you know, I've got like 15 people in my office, and it's apparently from some tenants union. And he said, okay, well, now you're going to have to talk to me. And I said, listen, we're going to do this the right way. It doesn't matter how many people you're here with. At the end of the day, I properly served the notice. You haven't paid any rent in the last 9 months, all right? And you have the audacity to then come in here and expect that, we're going to renew the lease after you took advantage of this poor old guy. Get the hell out of here. Are you kidding me? And long story short, I kicked them all out. I didn't care. It really did not faze me. I think it's hilarious, actually. And bottom line is we ended up offering, we actually ended up giving, I think, cash for keys, which is just an easier alternative sometimes for the landlord, which you can provide your tenant maybe $500 for them to vacate, and it provides moving costs. And I think there was only one guy, the guy who actually stirred all this up was the one who actually received the $500. And then the other people, they ended up moving 2 or 3 days after the agreement. So they had 30 days, but they ended up moving out in 34, 35 days. And, I was not entitled to give them a penny. So, and in fact, I probably would have if they weren't such assholes to begin with, and came in, there's a proper way to do things, and then there's an asshole way to do things. And that was totally the asshole way to do things, because, the best thing to do is actually like speak to your landlord. But if your asshole on the other, if your landlord on the other hand is an asshole, well then you know what, then I understand. But if it's someone who's actually understanding and likes to sit down and talk and mediate and finds solutions and sees the cup half full, that's not the approach that you want to take with someone who's like friendly and who's actually finding solutions. So just keep that in mind. Anyway, continuing. Attorney's fees. Except in eviction actions, the prevailing plaintiff in any action arising from the application of this ordinance shall be entitled to recover all court costs and reasonable attorney fees. And again, if you want a copy of this notice, you can always go to City of Chicago Residential Landlord and Tenant Ordinance Summary, and you can find that on Google. And going back to what I mentioned earlier about the unions, I think it's not a bad thing, but I think they just have to, and in fact, I'm all for unions, by the way, but there's a proper way to do things, and then there's an improper way to do things. And you have to understand those two differences. Okay? So with that, thank you so much. If you like what you heard, hit that like button and subscribe to the channel. Thank you so much.